whether case property can be returned to the petitioner accused when he admitted the case under Gaming Act. This question was discussed in one judgment. The judgment is that Andhra High Court Pendem Narendra Sanna P. Venkaya versus the state of Telangana represented by its on 22nd September 2014. Order. The petitioner sought for a writ of mandamus declaring that the seizure effected by the second respondent station house officer, police station Chilkur, Nalgonda district of the motor vehicle bearing number AP 24 UDTR 7583 Hero Honda HF Deluxe make and trying to auction the said vehicle in connection with case STC number 206 of 2014 as arbitrary. The petitioner, who has claimed to have purchased a motorcycle on 16th April 2014, is a postgraduate student of M.Pharmacy. As per the temporary certificate of registration issued by the Andhra Pradesh Transport Department, the name of the owner of the vehicle is shown as Sri Pendem Narendra, the petitioner here. The vehicle is under hypothecation with Sri Manikanta Auto Finance Munagala. The invoice raised by Sri Krishna Motors Miryaguda, Nalgonda district. Authorized dealer of Hero Honda motor vehicles issued on 15th April 2014 also disclosed that the vehicle is purchased by the petitioner herein. It is the case of the petitioner that on 17th July 2014 he went to his native village Jeripothalagudam village in Chilkur Mandal, Nalgonda district, and at about 4 p.m. he went to his agricultural fields on his motorcycle and parked the said motorcycle nearby the fields and went into his agricultural fields. It appears at about 17 hours on 17th July 2014, the Sub-Inspector of Police Chilkur Police Station raided the agriculture fields of Sri Gandu Ramaya, which are located at the outskirts of Jeripothalagudam village, where 4 persons were found playing cards by betting money. The police have apprehended all the 4 persons, one of whom is Pendem Venkana, the father of the petitioner herein. The police seems to have seized cash of rupees 9,820 and the playing cards, and also seized the motorcycle bearing registration number AP24 UDTR 7583 and 4 mobile phones from the spot under cover of a Panchnama in the presence of mediators and brought them to the police station. Yet, 1830 hours. A case was booked against the 4 offenders under Section 9, Class 1 of the Andhra Pradesh Gaming Act 1974. All the 4 persons were produced before the learned Judicial Magistrate of First Class Kodad on 18th July 2014. On the same day, the learned Judicial First Class Magistrate Kodad passed orders in STC number 206 of 2014. Since the accused have pleaded guilty for the offence under Section 9 Class 1 of the Andhra Pradesh Gaming Act 1974, the voluntary admission of guilt made by them has been accepted and the accused A1 to A4 are convicted under Section 252 CRPC and they are sentenced to pay a fine of Rs 250 each and in default to suffer imprisonment of 15 days. The seized cash of Rs 9,820 was ordered to be confiscated to the state. The playing cards and 1 counting paper were ordered to be destroyed after expiry of the appeal time. The unmarked property, including the motorcycle and the 4 mobile phones seized from the accused, were ordered to be confiscated to the state after expiry of appeal time. The accused have paid the fine of Rs 250 imposed on each of them. It appears when the petitioner has filed an application in Criminal MP number 2469 of 2014 in STC number 206 of 2014 seeking release of the motorcycle, the learned Judicial First Class Magistrate Kodad dismissed the said petition by his order passed on 5th August 2014, setting out that when the accused were convicted and the seized property, including the petition scheduled property, were ordered to be confiscated to the state after expiry of the appeal period, and when the confiscation orders are passed in accordance with the Section 8 of the Gaming Act, the said application moved by the petitioner seeking release of the motor vehicle as not maintainable. Hence, this writ petition is filed. Act. The Andhra Pradesh Gaming Act 1974, henceforth referred to for short as Act, has been made providing for punishment for gaming and for keeping the common gaming houses in the state. Section 2 defined various expressions mentioned in the Act. The expression gaming has been defined in subsection 2 in the following words. Class 2. Subsection 2. Gaming means playing a game for winning for prizes in money or otherwise, and includes playing a game of matka or satta and lucky wood and wagering or betting, except where such wagering or betting takes place upon the horse race. On the day on which the horse race is to be run, in an enclosure which the stewards controlling the horse race or race meeting have with the sanction of the government set apart for the purpose and with a licensed bookmaker or by means of a totalizator, but does not include a lottery. Subsection 4 of Section 2 define the expression instruments of gaming as under instruments of gaming. Instruments of gaming includes cards, dice, gaming tables or cloths, boards or any other article used or intended to be used are as a subject or means of gaming. Any document used or intended to be used as a register or record or evidence of any gaming, the proceeds of any gaming and any winnings or prizes in money or otherwise distributed or intended to be distributed in respect of any gaming. The expression common gaming house is defined in subsection 1 of section 2, class 2. Thereof reads as under common gaming house. In the case of any other form of gaming, any other room, rent, enclosure, vehicle, vessel or any other place whatsoever in which any instruments of gaming are kept or used for the profit or gain of the person owning, occupying, using or keeping such house, room, tent, enclosure, vehicle, vessel or place, whether by way of charge for the use of such house, room, tent, enclosure, vehicle, vessel or place or instruments of gaming or otherwise howsoever. From the above definition, it emerges that playing a game for winning the prizes in money attracts the expression gaming. Similarly, playing cards and other articles used or intended to be used as a subject or means of gaming attract the definition of instrument of gaming. A vehicle or a vessel in which any instruments of gaming are kept or used for the profit or gain of the person owning such vehicle, whereby charge for the use of such vehicle or vessel attracts the definition of common gaming house. Section 3 provided penalty for opening a common gaming house. It has provided imprisonment for a term which may extend to 6 months and with fine which may extend to 1,000 rupees for the first offence and imprisonment for a term which may extend to 1 year and with fine which may extend to 2,000 rupees for every subsequent offence. Section 4 provided for penalty for being found gaming in a common gaming house. Section 6 provided for an adverse presumption to be drawn where instruments of gaming are found at a place entered as such under Section 5 by any police officer not below the rank of Assistant Commissioner of Police within the city of Hyderabad and the Deputy Superintendent of Police elsewhere, and to presume such a place is used as a common gaming house and that the persons found therein were present there for purposes of gaming, although no gaming was actually seen by the police officer or any of his assistants. Section 8 provided for instruments of gaming found at a common gaming or about the person found therein, to be forthwith destroyed or forfeited upon conviction of any such person. Clause 2 of section 8 also enabled an order to be made upon conviction. All or any of the securities for money and other articles seized not being instruments of gaming to be sold, and the proceeds thereof together with all monies seized to be forfeited. Section 9 provided for the penalty for gaming. Therefore, all the important provision to be considered in the above case is contained in section 8, which reads as under section 8, instruments of gaming, etc. Instruments of gaming, etc. found in a common gaming house may be ordered to be destroyed or forfeited on conviction. On conviction of a person for opening, keeping, or using or permitting the use of a common gaming house or gaming therein, or being present for the purpose of gaming, the convicting magistrate 1. May order all the instruments of gaming found therein or on or about the person found therein to be forthwith destroyed or forfeited. And second, may order all or any of the securities for money and other articles seized, not being instruments of gaming, to be sold, and the proceeds thereof with all money seized to be forfeited, or any part of such proceeds and other monies to be paid to any person appearing to be entitled thereto. Section 8 has provided for two separate components. The first dealt with the instruments of gaming found at the common gaming house or on or about the person found therein. Upon conviction of such a person, such instruments of gaming may be ordered to be destroyed or forfeited. While the second limb provided for all or any of the securities for money and other articles seized, not being instruments of gaming, to be sold, and the proceeds thereof with all money seized to be forfeited. Therefore, for the second limb of section 8 to come into play, the charge that must be laid against the accused should clearly bring out that the various other articles which have also been seized at the common gaming house and are on or about the person found therein are actually the articles which are used as security for money. Then they can be ordered to be forfeited upon being satisfied that such articles are used as security for money by the person who was convicted. Further, Clause 2b enables any part of such proceeds can be paid to any person appearing to be entitled thereto. In other words, before any articles which are seized or ordered to be forfeited, they must be specifically charged as to have been used as a security for the money by the person who is found indulging in the act of gaming and who has been convicted under section 9 for that offence. In the instant against them that the motorcycle and the 4 cell phones seized at the common gaming house are used by any or all of them as securities for money. In the absence of any such charge laid against the accused, the learned judicial magistrate of first class Kodad could not have ordered them to be forfeited. Further, the motorcycle is clearly owned by the petitioner. Maybe it must have been found at the common gaming house, which was raided by the police, and further, maybe the first accused is none other than the father of the red petitioner. But so long as no charge is laid that this motorcycle is used as security for money, it could not have been ordered to be forfeited by the magistrate under Section 8 of the Act. Admittedly, the motorcycle and the 4 cell phone instruments are not attracted to the definition of instruments of gaming. Hence, so long as the articles are not used as securities for money, Class 2 of Section 8 does not get attracted. Assuming for the sake of argument that after conclusion of trial, as per Section 452 CRPC, the court may make such order for the disposal by destruction or confiscation of any property which is produced before it, but then such property should have been used for the commission of any offence. Thus, so long as the property produced before the court is not alleged to have been used for commission of any offence, as is also required incidentally by Section 8 of the Act, such property is liable to be delivered to the person entitled to possession thereof. Therefore, the order passed by the learned judicial magistrate of first class Kodad on 18th July 2014 in ordering forfeiture of the motor vehicle and the 4 cell phones went beyond his jurisdiction. To that extent, the order passed by the learned judicial magistrate of first class Kodad on 18th July 2014 and STC number 206 of 2014 is unsustainable, and accordingly, the order of the learned judicial magistrate of first class Kodad in STC number 206 of 2014 to the extent of ordering for forfeiture of the motor vehicle bearing registration number AC24 UDTR 7883 and the 4 cell phones is set aside, being unsustainable, and accordingly, in order to serve the ends of justice, the second respondent police is directed to restore them to their original owners immediately. To the extent indicated supra, the writ petition stands allowed no cost. So, here the answer is, if no charge is framed that is motor vehicle or cell phone, etc. In the absence of the charge, they cannot be ordered to be forfeited as per the section 8 of the Gaming Act. In admission, there is no charge. Hence, the property except money and play cards, other property cannot be ordered to be forfeited. Only after full trial and framing separate charge for the property found at the gaming house, that is motorcycle or cell phones or any other valuable property. After trial, when accused was found convicted, found guilty, then only the property order to be passed to forfeit the seized property. This is the answer we found in this judgment.